Mario, who's an attorney who works on account suspension, but also in dealing with arbitration.
I think Amazon is quietly trying to get rid of all the non-PL sort of resellers.
Amazon's policies is deliberately unclear.
Amazon isn't going to retaliate or sort of put you on a blacklist because you took them to arbitration. $60,000 to $80,000 on average that the client is going to spend.
Good afternoon, and today I'm speaking to someone who has been very helpful to our sellers and is well known in our community. Mario, who's an attorney who works on account suspensions, but also in dealing with arbitration. So tell us a little bit about your background first and why a seller would want to go to arbitration against Amazon.
Perfect. Thank you, Ed. And thanks again for having me on here. So as far as my background goes, Ed, I started selling on Amazon when I was in law school, right? I was in my second year of law school. Everyone else was going out, sort of getting jobs and all of that. I was like, I don't like that idea. So I came across this video by Ryan Moran. Back then he had YouTube videos and still does, but he was talking about PL and all of that. So took some money, ordered products, and sort of built a PL brand. Fast forward to 2018, I had two brands, sort of sold those, and then started this law firm. So we've been around for about 7-8 years now. June 1st of 2018 is when I started. So that's our anniversary date. But we help out sellers anything from sort of regular ACE and reinstatement all the way to something as more complex as arbitration. Right. And what I wanted to discuss today here is sort of arbitration, a little bit of information about it, and then what cases make sense to take to arbitration, what doesn't, and then the timeline, costs, and all of that. So if it's okay with you, we could just jump in and get started.
Yeah, so first of all, what would have to be the dispute for an Amazon seller?
To take to arbitration?
Yeah, like if they owe me $25,000, if they lost inventory,
Yeah.
if I'm not suspended, if I am suspended and they owe me. So when is it worth it?
Yeah, good question. So the best cases that we like to take to arbitration is when Amazon has lost inventory or damaged inventory, or somehow we sent in the inventory and we've got good evidence, but they never received it, or there's funds being held. Those are the situations where it's either inventory or funds, right? What I don't like to take to arbitration is, hey, my account's suspended and I want to go to arbitration and sort of get it reinstated. We really haven't seen a reinstatement like that happen. That's been our experience. We only had this one-off case, and I could talk about that too, where we were able to get a reinstatement, but that's sort of just a one-off, which again, I could discuss. But those are the situations that you want to take to arbitration. We've had sort of one-off cases like the one that I mentioned with the account reinstatement, also situations where our client will come to us and say, hey, I've got a medical device. This medical device needs FDA certification. We have that, but I've got these other sellers on here that aren't FDA certified. I've tried complaining to Amazon, nothing works. Like, this is serious. We're losing a lot of money. In that case, I'll say, okay, let's go ahead and take it. And cases like that, we've been able to successfully resolve. So sometimes we'll do these cases where we're like, we know we're not going to see you again for like the next 25 years, right? But normally it's inventory or funds held.
What do you say to someone where it's a large amount, let's say $500,000, but the account is active, account health is good, and they don't sort of want to rock the boat, but they feel that they have overwhelming evidence that Amazon owes them $500,000?
Because of inventory or funds being held? Is that the question?
Inventory. Well, if the inventory is being held in the account is not perfect, but what I mean is, let's say the inventory is lost, inbound shipment, and they're not.
So the account is healthy. So taking a case like that to arbitration, it doesn't affect your rights as a seller or your sort of account health. This is a very common question that a lot of our clients have is, look, my account's healthy. Am I going to sort of rock the boat if I take them to arbitration? This was something early on where we asked their attorneys, several of them, and they all said no. And fast forward, we've seen that in practice where if the account's healthy, you could still take it to arbitration and everything is still fine. So
Right.
I would say that's not an issue. Amazon isn't going to retaliate or sort of put you on a blacklist because you took them to arbitration.
How about, because I also know sellers who they're keeping lists where Amazon owes them a lot of money for different reasons, and they know they're not going to sell forever, and they say, okay, I'll go back and I'll go to arbitration at the end because they don't want to rock the boat. Is there a timeline when I can go to Amazon saying that they owe me money?
So I would say the best time is looking at the damages. So if it's, for example, a list of, hey, Amazon messed up over here and that's 25,000, here's another 50,000. I would say when that gets to around $200,000 is when we should act, right? And from there, doesn't mean that we can't have another lawsuit later on, right? Or another arbitration, I should say. Just because we had one lawsuit doesn't mean we can't file another one in a year later or 2 years later or 10 years later. It's not just one ticket to arbitration that we get.
But can I reference a loss that happened 15 years ago?
So obviously 15 years ago, there's no set limit because it's arbitration. The rules are a little bit more loose, but I would say don't wait that long, right? Just because, for example, in some of our arbitration cases, what we like to do, Ed, is have our client, the seller, be a witness, right? I think there's nothing better than the arbitrator hearing the story from the seller, from our client themselves. So because you're going to sort of forget and the arbitrator may not really sort of credit you or sort of believe everything that you say because it happened so long ago, I would say probably don't wait 15 years. I would say you should be looking at probably 2 to 3 years as a max.
So then walk me through why the number is 200,000 and not 50.
Correct. So with arbitration, anytime we go to arbitration, there's three sort of buckets of fees. Number one, obviously, you have your attorney fees. But number two, you have the AAA fees. Think of those as like the filing fees or court filing fees, right? And then number three, you have the fees to the arbitrator. Arbitrators we select early on based on our sort of selection process and Amazon. We rank them and then the arbitrator decides. Now, the arbitrator fees can range from, let's say, $300 all the way up to $1,000 an hour. Those fees are split between Amazon and ourselves, right? So our client pays half of that hourly fee and Amazon pays the other half. Now that can add up. So when I say the damages should be 200 or more is because on average for arbitration, Ed, you're looking at about 60 to $80,000 on average that the client is going to spend. So if it's damages of $50,000 or $100,000, it doesn't make sense for you to spend a dollar and get 50 cents back or to spend a dollar in the hopes of getting $1.20 back. So it's just a ROI that we try to do. Obviously, the more damages, the better. Arbitration makes more sense. But the threshold that we usually have is $200,000 in damages or more for us to really consider arbitration.
So I know you've had some success where you start the process, and now obviously the majority of them get settled somewhere along the line, but where you didn't even go to arbitration
Mhm.
and you've had a decent result.
Yeah.
So if let's say wouldn't it make sense for every seller to try to get that?
Absolutely. So arbitration we consider as like the nuclear option. We don't suggest arbitration unless you've tried everything else before that, right? We're talking about appeals, contacts to Amazon, all their other departments, escalation to other agencies, and then even pre-arbitration or what we call synthetic arbitration. I'd rather see all of that before we go to arbitration. All of those are going to be faster and cheaper for the client instead of just going straight to arbitration. Yeah.
Pre-arbitration may make sense for $50,000.
Absolutely, 100%.
Right. So I think that's important to know that if there's a dispute and you don't want to get involved and spend $100,000, you can try this. This is a pretty not a nuclear option, but you could try synthetic arbitration the stage before, and maybe that'll shake them up if your case is very strong.
Exactly. And it also helps us understand what Amazon's position is going to be when we get to arbitration, right? So even if a client comes to me and says, we've got $1 million in damages, I'll say, let's try synthetic arbitration first before we go over there, right? It's just in the best interest of the client to sort of try that cheaper and faster option rather than going the nuclear route right off the bat.
Right, but wouldn't Amazon try to fake that they were going to go and fight, and then because if they see that, I mean, and that's how the lawyers always work. They always pretend they're going to fight all the way to the end. But technically, Amazon could just say, okay, let's go to arbitration, and then they could settle like a minute later, right?
And obviously that does happen too, right? But you give them the opportunity to sort of settle because at the end, they're running a business too, right? They're doing a cost benefit analysis. And especially if they know that this law firm that sent them the demand letter for pre-arbitration or synthetic arbitration has taken them to arbitration before, has won before, their calculation is going to be different rather than, for example, an individual sort of sending it and saying, I'm going to take you to arbitration if you don't do ABC, right? So they're just doing their cost benefit analysis. And something else I'll say, Ed, is Amazon, what we're seeing now is Amazon is changing their strategy for arbitration. They're making some new legal arguments that we haven't seen before. So obviously we're adjusting as that's happening. But currently we have about a dozen arbitration cases. So it gives us a good understanding of what arguments they made before, what arguments they're making now. And we are seeing a different approach with Amazon's attorneys.
So are they being more aggressive, less aggressive?
I don't know about less aggressive or more aggressive. It's just a different tactic that they're sort of changing to. And I don't tell you what that tactic is or that what that legal sort of positioning is, but it's just different, right? So obviously something before wasn't working or wasn't working according to their standards. So now they're looking to change it. The new arguments that they're making that we've seen in the last three arbitration cases that we filed is them arguing that in order for you to sort of get your funds or inventory, you complying with the Amazon BSA and its policies is a precondition or a prerequisite. So their argument now is, Ed, you violated our policy A and B. So because of that, that you complying with those policies is a precondition to us releasing your funds or inventory, right? So obviously everyone's adapting to this, or whoever, whatever attorney is aware of this and is in this space is adapting to this, but that's what we're seeing on our end.
Right. Are you allowed to give me like the percentage of time that it actually goes to an arbitrator for like a hearing all the way to the end? Is that
Yeah, absolutely. I could definitely share, and obviously whatever I share is just our experience, right? So settlements happen about, I would say, 90% of the time, right? It just makes sense for all parties. But so what has also changed in the last, let's say, year to 18 months is before settlements would happen in or around discovery, when we started discovery. Because if you think about the phases of arbitration, it's sort of complaint, and then you have the hearing where all the parties get together and sort of set the agenda. And then from there, we get to the discovery. Discovery is where we ask them for documents and information, and they do the same to us, right? So previously, that's where settlement conversations used to happen. Now we're seeing that pushed into like right before the night or sort of weeks before the actual evidentiary hearing, where we spent all this time and all this energy in preparing for that hearing. Then they'll sort of come and say, hey, do you guys want to sort of talk about settlement? Right. So
right?
again, just to sort of short answer to your question is about 90% of cases usually settle, but we're also selective about the cases that we take, right? We're not going to just take any case to arbitration. In our experience, it's about 90% of the cases settle. But once again, Amazon is changing its strategy. So I don't know how this is going to change how they settle or if they settle. So we'll
Do
have to.
you do you feel the actual arbitrators, and even on the cases where you don't go to the end, you're still dealing with the arbitrator. Do you find that they're overly sympathetic towards Amazon because they're Amazon?
Good question. So a lot of it comes down to the arbitrator, right? Arbitrator has a lot of discretion. And what I could tell you is arbitrators are supposed to be neutral. But if we really think about it, and I don't think this is a secret, Amazon is a client of the AAA, of the American Arbitration Association. If the AAA Arbitration Association, if they don't play ball, again, this is just sort of my opinion, Amazon could very easily change and say, we're no longer going to be using the AAA. We're going to go to another sort of framework, for example, another association such as JAMS, right? Which is just another sort of, think of it as a court system for arbitration cases. So that is there. Do I think it affects it a lot? I want to say, or I want to sort of think that it doesn't. But all I'll say is arbitrators do have a lot of discretion in these cases.
Right. And have you seen any arbitrators? Because some arbitrators you would think would automatically be against Amazon.
I don't think that's fair to say. So the way the selection of the arbitrators works is once we start the AAA process, the arbitration process, the AAA will give us a list or a roster of like 10 arbitrators. So we have to research them and see, for example, what their political affiliation is. Well, if they're an attorney, what sort of clients were they representing, right? And how they feel about that. Looking at their social media things to see what are they commenting, and is it likely, again, it's just an educated guess, but are they more likely to be for smaller sellers and entrepreneurs or against them? And obviously, Amazon is doing the same thing too, right? Of
Right, because Amazon is trying to find somebody who's going to be
course, of
sympathetic towards them. This
course.
whole thing is fascinating. This whole world of arbitration, I found it extremely incredible. Did you do any arbitration against TikTok or eBay or any other platforms, or you stick just to Amazon?
No, for now, we haven't seen any major issues because TikTok is so new. We haven't seen any major issues that would warrant that. We're now starting to get clients that'll come into for TikTok, but it's usually IP protection and IP sort of slash brand enforcement. But we haven't seen that. And to be quite honest with you, Ed, I also haven't seen the agreement with TikTok and whether arbitration is required or not. I could tell you, for example, with Walmart, arbitration isn't required. You could sue Walmart.com, right? You would be suing them, I believe, in Arkansas, but that's where you could sue them.
Right, right. So they don't like them. I mean, with Amazon, it's more of an issue because they're holding your inventory. That's really they're holding your inventory, they're holding the money, and they're so secretive that you don't even know what you did wrong. And then like technically, see, my problem with this whole process is that the agreement says that if there's fraud and abuse, then they're allowed to do whatever they want with you. But they define what fraud and abuse is. And there's so much context. No, the arbitrator, who's probably like 70 years old and never saw nothing against that, but
Yeah.
who probably never doesn't know anything about Amazon selling, he doesn't know the ecosystem, and he hears fraud and abuse, and he hears on the news there's fraud and abuse, and he's fraud and abuse. So, and that's really, I feel like the disadvantage what a seller has going into arbitration. That's my opinion. What's your statement on that?
Yeah, listen, Amazon can say fraud when it's just sort of the seller or them, right? But when it gets to arbitration, I mean, fraud is a legal term and it does have a definition. So it's unless the client or the seller has obviously committed fraud, it's very easy to disprove that. But in the past, Amazon's arguments have always been policy, policy, policy. This is our policy, this is our policy. So our sort of objective and our goal is to say, look, that's your policy, but is it in violation of any, for example, Washington state laws or just sort of public policy? So some of it is we're definitely fighting an uphill battle because it's Amazon, but also keep in mind the BSA that they wrote, their attorneys, I'm sure at least 20 attorneys were involved, all of them receiving about charging Amazon about $1,200 an hour, right? So it's like they know what they're doing. And it's definitely an uphill battle. I don't want to make it seem like this is all sort of easy and anyone can do it and it's always successful. That's really not the case.
Right. So a lot of case, I mean, but how about in a case where, which I know a lot of people have had, where Amazon suspended them because they received inventory from an unverifiable supplier.
Like
And
an inauthentic suspension.
yeah, I mean, where's the fraud and abuse? Because he didn't want to give me the
Yeah.
his supplier, so it's fraud and abuse. So that's one. And then how about a case where a supplier gave me an editing invoice and I didn't know about it? And it happened one time. They're gonna say
Yeah.
fraud and abuse.
Yeah.
And the only reason why it was edited is because the name didn't match the information on the account. So if you don't know anything about Amazon, you can say, ooh, fraud and abuse. But
Yeah.
within the Amazon seller ecosystem with the context, it's explainable. So
Yeah.
how does that work?
So it's funny. We just had a hearing about this maybe about a month or 2 months ago where a client was suspended for inauthentic suspension and Amazon was holding inventory and funds. And Amazon's witness that they brought was one of their compliance managers, not an attorney, but compliance managers. And I was the one cross-examining them, like asking them questions and things like that. And I really started off with sort of like, this you guys believe is inauthentic. Have you guys done any test orders? No. Has anyone done test orders? No. And the product in question, I'm not going to give the name, but let's just say it was like a cosmetic product, like any lab test to determine whether this is like a real formula, all the ingredients are in there, or whether it's not. No, they haven't. Right. I also started with sort of saying, if there's a recall on a product, right? Forget about inauthentic. If there's a recall on a product, like what happens? Amazon notifies all of their customers and says, Ed, you purchased that, for example, rice cooker. It's received a recall. We'll either give you a refund or sort of return it in or something like that. But there is notification to those people. So if you guys believe that this is inauthentic, did you guys notify all the customers who purchased it?
No.
No. Okay. Let me ask you another question. If I purchase this iPhone from Best Buy, and if I sell this on Amazon, according to your policy, I'm asking this guy that this question, right? Like I don't have the full supply chain. So would this iPhone be considered inauthentic? And he said yes. On the record, the arbitrator's there, right? So those are the type of questions that we could bring up and sort of during the evidentiary hearing if there is no settlement, where the arbitrator's probably looking over there thinking, wait, what's your policy? Right? And again, brought up another example from like Costco, if I buy this. And again, he said, yeah. So it's ridiculous. And that's what arbitration allows us to do is really put how, I don't want to say dumb or stupid, but just how some of these policies are just ridiculously written, right? And how it's even enforced. Where outside of arbitration, we can't do that. But again, not every case belongs in arbitration. But if there's a good case, if there's a good client, if we've got good evidence, then fine, let's go ahead and sort of take it to arbitration. But that's sort of a longer answer to your question.
Right. Because I think there's a little bit of an intersection here between, but not understanding the context is that, like I would say even if 12 years ago somebody sent me an ungating service sent me a document that was created. So technically, they could say everything you sold on that account is fraud, and it is. I won't even disagree. But if you understand the ecosystem in 2018, 2017, there was no other way. I'm not justifying it at all, but people were going to ungating services, and then they were selling legitimate product. So you could just say he submitted a fake doc and it's fraud. You could say like that. But if you explain with more context, one may say that it's not fraud. It's just standard Amazon selling, and certainly not enough that you should hold my money in inventory.
Yeah.
Do the arbitrators understand that Amazon's policy, I think that's your job to explain that Amazon's policies is deliberately unclear?
Exactly. Not just unclear, but I also believe unfair, right? It's definitely unfair. So again, it's the attorney's job to try to help the arbitrator see that. Now, is it always successful? No. But I think if you've got sort of good client that could get on the witness stand and sort of say, this is who I am and all of that, and then have a good enough attorney to sort of help show that, that's what it is. But in the past, Amazon's arguments have really been, this is our policy, this is our policy, this is our policy, right? And again, some arbitrators may say, that's BS. That may be your policy, but it's not fair at all. And others may say, well, that is their policy, right? You signed up to it. You're a big boy. You signed that. Mm-hmm. So that's really what it comes down to. But I think all of this really comes down to the underlying fact that, and I called this 3 years ago when I wrote that book over there, Amazon, I believe, is, although they've never announced it and they probably never will. But I think Amazon is quietly trying to get rid of all the non-PL sort of resellers, all the wholesalers, all the arbitrage sellers. Because if you think about it, what is the inauthentic suspension really for? It's not for the P&L seller, for PL sellers. The private label sellers can easily show those documents. I've never seen a PL seller, private label seller, get suspended or ASIN suspended for inauthentic complaints.
I would say that, but basically what you're saying is, and I agree, is that they could use enforcement as a way to cull the herd or to have less sellers of a certain brand, which because if they just say we don't want resellers, they can't go so far and it won't look good. So I feel like they're using their unclear compliance rules as a way to get rid of sellers. And the counter argument is that if you don't want us sellers, why are you holding my inventory and my money? Give me 90 days and let's part ways. You're not forced to do business with me, but there's a way of separating. And I think that's what happened is that Amazon unfairly they went overboard in enforcing instead of saying they don't want sellers and not giving a reason, they said that you're inauthentic and you did something wrong, and then it gave them the ability to hold potentially millions or billions of dollars.
Absolutely. And I guess a better question is, if you believe that this product is inauthentic, are you just going to throw it away because you're keeping it, or are you going to sort of liquidate it and sell it, right? And I think we all know the answer to that.
Yeah,
They're
yeah,
not
of
they're not
course.
burning it.
Yeah, I mean, they don't think for a second it's inauthentic, but they're able to say that we think it's inauthentic. I think that's the
Yeah.
only threshold they have to hit. So this is fascinating, and I love this stuff. So Mary's an amazing person, an amazing attorney. He's going to be at the event, and he's sponsoring the live stream, and he's personally going to be there. And he probably spoke to around half the people who are going to be there, or something like that. But many people. And he's also going to tell us a little bit about the book you wrote, which you're also giving out free to all attendees.
Yeah, so I wrote this a few years ago, and really the way I see it is with e-commerce sort of developing and growing the way it is, I think everyone, well, with attorneys, they need to be sort of on the corner of IP and Amazon, right? There's a lot of IP issues that happen on Amazon. And this was really written for private label sellers, just giving them a basic understanding of what is IP, what you need to sort of protect and how to protect it. And this comes from my own personal experience. I mean, when I was a seller, this is a story I don't share very often, but I got very, very sort of maybe cocky. And when all my products were selling, I ordered 4 or 5 large rolls of artificial grass. At the time, the city of LA or county of LA was giving sort of rebates to anyone that would go ahead and put that on their lawn. So I thought it'd be easy to sell. But I realized that I can't do anything with this on Amazon. Like now I'm sort of listing this on Craigslist and all of that. So it just wasn't selling. It sat there for about 6 months until one day I'm looking at those big rolls in the driveway and I'm just having my morning coffee and I'm like, what if I cut it up and make it into doormats? Right. So that's what I did. I hired a few guys from the local Home Depot, had them cut it up, put it in Uline bags, sort of use a color printer to sort of put the label on there and sell those. I was the first person to do that, to have the artificial grass as sort of doormats and sort of runners, right? After that, at the time, I didn't realize like, how am I supposed to protect this and all of that, right? So it's like that, I think, cost me probably a few $1,000,000. So the buck is to sort of, how do you avoid something like that? Right. So that's what it's for. And like you said, we'll be giving those away to the attendees.
Right. Okay. Very excited to meet you personally. And I think it's going to be very well received. And thank you so much for coming on. And I'll see you March 5th. Looking forward.
Perfect. Appreciate it. Thank you, Ed.